So we're in your government book and we're continuing with reviewing the Constitution of the United States. I kind of got a phone call in the midst of last, so I'm just going to keep going from where I left off. We were going over the Constitution. We went over the preamble. We went over Article 1 of the Constitution has to do with the legislative branch and everything to do with Congress, going over the House of Representatives and going over the Senate, which we already did in the last section. And based on the Senate based one senator from each state, and the House of Representatives based on population. We went through the elections and meetings of each and onto the legislative procedures. We finished there. Onto the powers of Congress, what they could do. We went over all of the duties of Congress, whether it was the House of Representatives onto the Senate, and what kind of laws they can make. And we got down to on page 245 at the bottom, which talks about the elastic clause. So we talk about the elastic clause here. Let me get a pointer here so I can show you where you can kind of see. So the elastic clause being right here. And so it says this clause gives Congress the authority to make operational through laws and powers already granted. It does not grant any additional powers to the Congress, although it has been used in recent years. The elastic clause, they call it elastic because they're stretching the powers of the Congress. And so basically it says Congress has the authority to make new laws and such powers that are already granted. So they have the power to mint money or tax and those things, but the Congress also knew that they needed a bank. And so the bank was part of the elastic clause because in order to do these things, they need this. And that's what the elastic clause is about. Although now Congress stretches it as far as it can in certain areas to give the government more power. So the elastic clause, that's the clause that's used a lot with liberal government, saying, okay, we can stretch this any way we want to do anything we want, which is really not a good thing. We don't want so much power. We want the government to have too much power, especially in making laws, So that's the elastic clause that was written. It's basically to make laws, which here it is right here, to make laws which shall be necessary and proper for carrying out the election and foregoing powers and all other powers vested in this Constitution in the government of the United States. So it just says necessary and proper clause is the elastic clause. So let's go on. Powers that are denied to Congress. What can Congress not do specified by the Constitution in Section 9? Powers denied, and I'm reading from over here because this is where you're going to do. So if you're doing your test and everything, or doing your worksheet on this, just look up and it tells exactly. Powers denied. Congress should not abolish the slave trade until after 1808. So they put down, they had the slave trade until 1808, then Amendment 13 abolished slavery altogether. So that's one. Congress cannot suspend the writ of habeas corpus. What is habeas corpus? It gives an accused person the right from a prompt appearance before the judge to determine if he's held legally. Habeas corpus is they just can't come and take you and just hold you. First of all, without a warrant, but also they cannot hold you unless you first are judged by the judge that you can this be. So habeas corpus protects the individual unless it's during wartime. And then they could hold about anybody, right? So the writ of habeas gives an accused person the right to a prompt appearance before a judge to determine if he's being held legally. Habeas corpus. No bill of attainder means a bill to punish a person without a jury trial. So they can't attain you without a jury trial. No ex post facto law. Ex post facto means, ex post means post facto, making an act of a criminal after it has already been committed. So say that this person committed a crime, but it wasn't illegal back then, but now it's illegal. You can't go back to the ex post time, to that time and have to be put in jail for a crime that wasn't illegal at that time. So ex post facto, making an act criminal after it's already been committed. So You're saying, okay, you committed this crime back in 1980, and it's now law, so we're going to go back in time and put you in jail. They can't do that. So Congress cannot order any direct tax unless it is in proportion to the census count of the various states. Well, since then we have the 16th Amendment, which we have income tax. Before that time, they could not directly tax the people at all. So until the 16th Amendment for levying taxes. Congress cannot levy export duties on goods sent from one state to another or on goods sent to foreign countries. So Congress cannot put taxes on states, between states when they're exporting goods or to foreign countries. Congress cannot give preference to one port over another, saying you have to use the port of New York. They can't do that. Congress cannot force states to pay duties on goods traveling by water or air from one state to another. Same thing, paying duties on one state from another. Congress cannot set forth money there. Congress cannot withdraw money from the Treasury except for laws passed. Congress can't go say, okay, we're just going to take some money out of the Treasury. They have to have laws to take the money out of the Treasury. Let's just say that. A statement that shows the payments and receipts of the public money must be made periodically. So they have to publish what they're doing. When they take money from the Treasury, they have to publish exactly what they're doing. Congress cannot grant titles of nobility. They can't grant titles. Congress can't say you have a title as a king or you have a title. They cannot do that as they do in England, like knight somebody or give you a title of nobility. Congress can't do this. No official may receive gifts or titles of rank without the permission of Congress, okay? Section 10 has the powers denied to the states, okay? Those are the powers denied to Congress, but now the states cannot do some things. The states cannot exercise powers that are expressly given to the federal government. So if the federal government says something is illegal, and a state can't say, well, in our state it's legal. No, they can't do that. So they cannot exercise powers that are given to the federal government. The states are not to exercise powers that have been denied to the federal government in which they deny the rights of the citizens, okay? No state may impose import or export duties, that's money. The states may collect inspection fees, but these fees must be paid to the treasurer. So a state cannot take money imported or exported, those duties, and the inspection fees must be paid. Congress can change the state's inspection laws, though. So the states may not charge a tax on ships entering their ports. So if a ship comes in their ports, they can't tax them, right? They may not have an army or a navy. A state can't say, this is our own army or this is our own navy, right? They may not make treaties with each other or with foreign nations. One state, like the state of California, can't make a treaty with Russia or something. A state may not declare war, and that's what happened in the Civil War, is that the states withdrew from the Union and declared war. But it's saying here that states cannot declare war. The above powers are delegated to the federal government. So these powers, declaring war and having an army or a navy and making treaties, these are for the federal government, not for the states. Okay, now we're going to get into the executive branch, which starts with the president and the vice president, which are ahead of the executive branch. The executive branch is to carry out the laws, to make sure they're carried out. So the president and vice president have the power to execute or carry out the laws that were given to the president. And the president and the vice president are elected to how many terms? 4-year terms. They could only have two 4-year terms, sorry. The state's legislators set up rules by which the electors for their states are chosen. So when we talk about electing a president, then we talk about the legislators setting up the rules for electors. Remember, we're going to talk about the electoral college. Excuse me, I have this allergy here. The number of electors for each state is equal to the total number of senators and representatives of the state. So we're talking about the electoral college here. And that's when you have, you basically have running for president, they were going to elect a president, will have electoral college, and the number of electors for each state has to do with how many senators and representatives the state has. So if the state has, so many in the House of Representatives, say it has 20 in the House of Representatives, and then it has 2 senators, of course, in that they add that together, plus, in the midst of all that, how many, in the midst of all that, they find out that's how many are in the Electoral College. And also, Washington, D.C. has electors now too, so in the Electoral College. No federal officer may be elector. That means you can't be of the Electoral College if you're already a federal officer in the government. This manner of electing the president and vice president did not allow for the role of political parties. Did not allow for the role of political parties. In 1804, the Amendment 12, which states the present procedure for electing president and vice president, was adopted. So now it has a lot to do with political parties. Back then they didn't. So now electors, 100%, let's just say of electors represent their political party today, either Democratic or Republican. So if, say that a state wins the popular vote, then all the elector votes go to that president, to that candidate, right? So the Electoral College, and they have as many electoral votes as they have congressmen in Congress, right? The Congress decides on the day when the electors are chosen, the day they cast their votes, okay? The day will be the same throughout the country. So that's when the Electoral College casts their votes. The president must be, this is important here, the president must be a natural-born citizen. He must be at least 35 years old. So we have a couple young presidents. 2 of them would be Kennedy, and I think the youngest is Theodore Roosevelt. But they must be at least 35 years old. He must have resided in the United States for not 5 years, not 7 years, but 14 years in the United States. 14 years in the United States. He must be at least 35 years old, and he must be natural born in the United States. So he must be a natural born citizen, not born someplace else. He must be a natural born citizen, 35 years old, and 14 years, must have resided in the United States for 14 years. So he must have resided for 14 years. He must be natural born, and he must be 35 years old. Okay, over here, this is what I'm reading on the side. If the president is unable to carry out his duties, the vice president shall assume the duties of the president. Okay, so the president is unable to carry. If something happens to the president, who takes over? The vice president. If neither is able to assume the responsibilities, the Speaker of the House shall assume them. So the next, if you don't have the president, you don't have the vice president, the Speaker of the House is the next one. If he is unable, then the president pro temp of the Senate shall assume. It's just power. This isn't all in now in Amendment 25. So the president's salary may not be raised or lowered during his term of office, and he may not receive salary from any other national or state governments. That's important, their salary, huh? Each president must affirm to uphold his duties faithfully. The powers of the president. What can the president do? The president is the commander-in-chief of the armed forces. He can ask for reports about the work of each executive department. He can ask what's going on in Congress. He can pardon those convicted of crimes against the government, except in cases of impeachment. So he can pardon those convicted of certain crimes, especially against the government. Well, against the government, let's say that. The president can make treaties, which must be approved by 2/3 of the Senate. If they make a treaty, the Senate has to approve them, 2/3. He can make appointments to those positions which are not specifically provided for the Constitution. The Senate must approve of his choices. He can make appointments, but the Senate has to basically approve of those too. The president can fill vacancies that occur during Congress. He can fill those vacancies, but those positions are temporary until the next election, right? So he can fill those vacancies. Now the duties. Section 3 has to do with the duties of the president. He gives a State of the Union message. He has to give that State of the Union. When he becomes president in January, every president has to give a State of the Union message before Congress, which really states what he's going to do as president. He can convene either house for special sessions. He can say, okay, we're going to have a special session in the House of Representatives of Congress. He may adjourn Congress if they can't agree on a time. If they can't agree on a time, he can say the Congress is adjourned. He can receive ambassadors and other foreign officials. He is to see that laws of the land are carried out. That's his job. A president can be impeached. The president, vice president, and other officers may be removed from office if they are impeached and convicted of crimes. They can be impeached by basically the impeachment is charged by the House of Representatives, and then they're tried in the Senate if it's for the president. And they can be impeached, but, the impeachment may not come through. They have to be at least, I think it's 2/3. Maybe it's 3/4, but I think it's 2/3. The judicial branch is basically going to another branch. This is the court system. This is our judges, right? The courts. This is another branch. We have 3 branches. We have the executive branch we just went over with the president. We have the legislative branch, which is where we make the laws in Congress. And now we have the judicial branch. So the federal courts, the judicial power of the United States shall be vested in one Supreme Court. And in such inferior courts as Congress may ordain. So the Constitution provides for the Supreme Court and any lower courts which Congress deems necessary. The judges are appointed for what? For life. The Supreme Court judges are there their whole life, unless they are impeached or convicted, or they want to retire. If they want to retire, they can choose to retire. The judges are to receive a salary which cannot be lowered during their terms. So they can receive a salary and it cannot be lowered while they are in their terms. Jurisdiction of the courts. The courts have the power to try all cases that arise from the Constitution, the laws, and the treaties. So the Supreme Court, any case that has to do with the Constitution, has to do with the law or treaties, is the Supreme Court. The courts are to try cases regarding public officials, maritime, that's sea cases involving the United States, cases between 2 or more states, cases involving citizens claiming the same land granted by different states, and cases between the United States citizens and foreign governments or citizens. So basically they have jurisdiction. That means the Supreme Court. This is not appealing to them. This is their jurisdiction, their first jurisdiction. They had tried anything to do with the Constitution, anything to do with laws or treaties, anything to do with, the maritime cases, that means out in the sea and in the Navy and such, and cases involving the United States between 2 states, or citizens, that have land granted by 2 states when there's a state controversy. So the Supreme Court has original jurisdictions in cases regarding foreign officers or foreign officials or one of the states. That's original jurisdiction, not appellate. That means not appealed. The Supreme Court will try cases that have been appealed because of lower court's decision, appellant cases. So the Supreme Court can pick through all these cases that are appealed from different cases of the states that go, we're appealing it all the way to the Supreme Court, right? But they pick very few of these cases to appeal. And they don't have a trial for these cases. They just look at the cases and then they decide whether the case was done correctly in the lower courts. Congress has the power to remove whole classes of cases from court jurisdiction and to regulate court actions. That means Congress has the power to remove cases if they want to. The Constitution guarantees the right of trial by jury except in the case of impeachment. So our Constitution says we all we all have the right for a trial by jury, right? Trials are to be held in the state in which the crimes are committed. So if you have a trial, you are to be trialed in that state. You can't run to another state. If you're in another state, they'll come and bring you back to that state, and that's where you're to be tried. And Congress decides where cases are to be tried if a crime was committed outside the United States. So if it's outside the United States, Congress decides where you're going to be tried. Treason. What is treason? Treason is declaring war against the United States or helping an enemy of the United States. If you're helping the enemy, you can be committed treason. To convict a person of treason, there must be 2 witnesses or a confession, and Congress will decide the punishment for treason. Punishment for treason cannot be extended to the descendants of a person convicted. So if your dad is convicted for treason, that doesn't mean that you're going to be convicted for treason. So it cannot extend to the family. So Article 4 is about the states. Pretty important. State acts. Each state is to respect the acts and judicial rulings of the other states. So when a citizen of one state passes through or temporarily resides in another state, he is entitled to all the privileges and immunities of the citizens of that state. So if you're going to another state, just because you're coming to another state doesn't mean that you don't have all the privileges of that state. When you're in that state, you can't say, well, only citizens of the state get this privilege, The rule regarding extradition, pretty important. That means a person who has committed a crime in one state and he runs and flees to another state, right? And so that means that other state must return that criminal to the state where he committed the crime. That's called extradition. The governor of the state must request the criminal to be sent back. So basically the governor has to say, you need to send this criminal back here to our state so we can try him here. As referring to fugitive slave, this portion of the Constitution was replaced. So this, when it talks about slavery, that's done away with the 13th Amendment. There's no slavery anymore. The additions of new states. Congress may admit new states to the Union. Yep, we can get new states. New states may not be formed from existing states. You can't take a state and divide them in half. Or the joining of 2 more states together. 2 states can't join together and decide that they want to be a state without, basically, unless the legislature of the state, unless Congress approves it. Let's just say Congress can approve it. The state of West Virginia was admitted without the approval of Virginia, in fact. So that did happen with West Virginia. Congress has the power to make all laws governing territories and government properties that belong to the United States but are not states. So Congress has the power. We have the power like the territory of Puerto Rico. So Congress has the power of governing these territories. Guarantees to the states. The federal government is to make sure that each state keeps a representative form of government. All the states, all their state governments are representative state governments. That means they have the same type of form as the national government. So they all have representatives. They can't just, well, my state is a communist state. They can't do that. So the federal government will protect the states from enemy invasion. That means the states are protected by our federal government. Our federal government, national government, has to protect each state. The federal government will send troops to keep peace if the state legislator or governor requests such help. In some cases, troops will be sent into an area of violence without such a request, as in national welfare is at stake. So the federal government can send troops into certain states if there's unrest and the governor asks for help, right? So Article 5, amending the Constitution. How do we change the Constitution? Let's find out. The Constitution can be amended in the following ways. 2/3 of the members of each house of the Congress propose an amendment, and the legislation of 3/4 of the states ratify the amendment. So 2/3 of the members of the House of Representatives and the Senate, and then 3/4 of the states also have to ratify this amendment. 2/3 of the members of each House of Congress propose the amendment. So they propose the amendment, and special conventions in 3/4 of the states have to ratify it. So 3/4 have to ratify it. So 2/3 and 3/4. So that's good. To get 3/4 is a big number. 2/3 of the state legislatures call for special national convention to propose the amendment, and 3/4 of the states have to ratify that. And then 2/3 of the states call for special convention to propose amendment and special conventions. So these are the things. First of all, proposing the amendment takes 2/3 and 3/4, and then on to the special conventions, and then on to special national conventions for the purpose of an amendment, and on here down to for special conventions, the purpose of the amendment and special conventions. And these say, so 1, 2, 3, all of these, but they have to go through all that process. Just say it goes through a process. It takes 3/4 to be considered, and or 2/3 to be considered, and 3/4 of the states have to ratify the amendment to the Constitution. We haven't had very many amendments to the Constitution. Now, the state constitutions have amendments all the time, but our nationals and the national basically we only have 27 amendments to the Constitution in all these years. All debts and agreements contracted under the Articles of the Confederation would be valid after the adoption. This is basically, the Constitution took over the Articles of the Confederation. But what they said is that if the Articles of the Confederation had an agreement prior, especially an agreement money-wise, that the Constitution would not invalidate that. Would basically say they're valid. They're not there to do away with agreements under the Articles of the Confederation. So that's just an addition there when they brought forth the Constitution. The Constitution, the laws, and treaties made by the United States would be supreme law of the land, right? We know that. These were to have precedent over the states' laws and constitutions. Yeah, we know that. Precedent over the states. Since the Supreme Court's decision, Marbury versus Madison, we went through that. That was basically John Marshall, 1803, that basically said that the Supreme Court now has the power to decide whether law is constitutional or not. And this is known as judicial review. So it gave the Supreme Court a lot of power because they could say whether a law is constitution, whether that law is valid under the United States Constitution. All public officials must uphold the Constitution. No religious test should be required as qualification for offices, to take a religious test. Those things, of course, we know are important. Article 6, ratification of the Constitution. So this, when the Constitution was going to be ratified. The Constitution will go into effect after the conventions of 9 states had ratified. New Hampshire was the 9th state that approved the Constitution on June 21st, 1788. But you'll have to add that after 9 states had ratified it, still they hadn't added the Bill of Rights. But after they added the Bill of Rights to the Constitution, then all the states ratified the Constitution with the Bill of Rights, including Virginia and New York, which were holdbacks, and Rhode Island. And so here we have, says 1,787 of the independence of the United States. This is in the year, we're talking about the year of the independence of the United States of America, the 12th. In witness thereof, we have hereunto subscribed our names. So here are all the signers from all the states, the signers of the Constitution. So you'll see each state had, you see some familiar, you see some people that are not there. You don't see Thomas Jefferson, or you don't see John Adams. So they were actually, Jefferson was in France and Adams was in England. So you always thought that they did, but they weren't on. You see some familiar, like, of course, Alexander Hamilton, which kind of represents George Washington. As you go through, you'll see a lot. You'll see Benjamin Franklin, so these are the signers of the Constitution. Now I'm going to go through the Bill of Rights because these will be on your test, and I'm going to go through quickly, but I think I'll do that in another video.